Right, good afternoon, everyone. I can see we've got two competitors, and I can see my fellow judge, Amrit, there.
Hello.
Hello, Amrit. Can we just do Hamad? Which team are you from?
Me. I'm not from a team,
No,
so
no,
I'm
no.
a judge.
No, sorry, I wasn't. Sorry, I was talking to the other two
sorry.
who were on. Don't worry. Mohammed Umar and Mohammed Shoaib. Which team are you from? Can you hear me?
Sorry, sir, can you repeat?
Which team are you from?
We are from University of Bolton.
Oh, great. And which of you is going to be the senior counsel and which the junior counsel?
Sir, I'll be the senior class counsel, and Mohammed Omar will be my co-counsel.
Okay. Thank you. And Amrit, I have to ask, are you related to Dilpreet?
I am. Yeah.
Is she your sister?
She is.
Oh, right. I did wonder that. I did a long arbitration with her about in the DIFC about 3 years ago when she was at Denton's.
Yeah.
So yeah, I can see we've got Tasneem. I'm assuming you're from Hamad University?
Yes, from Hamad bin Khalifa.
Excellent.
My co-counsel is just logging in right now.
Excellent. Are you going to be the senior counsel or junior counsel?
So I will be the senior counsel.
Excellent. We will get started in just a minute then. think we have everybody. Before we begin, can I just ask, firstly, the appellants, how you're going to divide your time? Then I shall ask the same question to the respondent. You've each got 45 minutes, and the appellants also have the opportunity for some rebuttal. And so I ask the appellants first, the University of Bolton, how they are going to divide their time.
Sir, we will be dividing our time as approximately 22 minutes per person.
Right. And are you going to reserve any rebuttal time?
Yes, sir.
How much?
Around 5 to 7 minutes per person.
Okay. So that'll be about 17 minutes plus 5 minutes of rebuttal.
Yes.
And the respondent, are you going to just divide it equally, 22 minutes?
Yes, so about 20 minutes each, and then we'll leave 5 minutes for rebuttal.
I don't think the respondent gets a rebuttal.
Yes, I'm sorry.
So you don't have to worry about that. Once you've done your bit, you're over. You can sit down and relax. So unless anyone has any questions at the outset, I'm going to invite Senior Counsel for the Appellant to begin the moot.
Do I start, sir?
Please do.
Your Lord, my name is Mohammed Shoaib. I am the senior appellant on this case, and I'm going to be speaking on behalf of Mr. Leith Payne for the case of Mr. Leith Payne versus Ms. Razrani. Shall I proceed with the statement of facts, Your Lord?
Just give us a very brief summary of the facts, please.
Okay. So Clevity is a digital platform where users can trade using algorithms, and they can pre-program their algorithms beforehand to avoid human physical interaction. Ms. Razrani and Mr. Leith Payne are such users on this platform of Clevity. The platform has a minimum balance required to get involved in trades, that is of $50,000. And on 10th June 2022, there was a routine upgrade due to which caused an error, due to which the minimum balance requirement of $50,000 was raised to $200,000. And due to this, there was a disputed trade between Ms. Razrani and Mr. Leith Payne with their programs, namely Alpha and Beta. Alpha bought 100 YAPL, that is a certain type of cryptocurrency, for a price that is 250 times higher than the average price or the price at that time. And due to this, Ms. Razrani issued charges against Mr. Leith Payne on the court of first instance, and the case was moved forward to Digital Economy Court in DIFC.
Thank you.
Your Lord, shall I proceed with my issue?
Please do. You can assume that you can proceed with everything until I interrupt you, or my co-judge interrupts you.
Sure, sir, sure. The issue I will be dealing with as senior appellant is the issue of law. And it's very well established fact in this case that all programmers or users have pre-programmed their algorithms to conclude trades without physical human interaction. So when Ms. Razrani had programmed Alpha, she did it in such a way where Alpha would buy a certain cryptocurrency, in this case YAPL, at the best rate possible, which is the cheapest rate possible out of all the sellers. And Mr. Leith Payne's program was programmed in such a way where it would sell a cryptocurrency, in this case YAPL, at an average price. But in case of no other sellers offering to sell YAPL or a cryptocurrency at any time, Beta would automatically inflate the prices of YAPL and sell it to whomever it may concern. In this situation, we asked ourselves a question that when Beta sold YAPL to Alpha at a price that is 250 times higher, and this was posed as an issue for Ms. Rajrani. The question we asked ourselves repeatedly was if there was no glitch on 10th June 2022, or there was no routine upgrade or any other error on the platform, and the same trade would have occurred, because as there is a possibility for such trade to occur without a glitch, would she issue the same charges against Ms. Lathpain? And the answer is in the question itself, your Lord. As both programs, Alpha and Beta, they concluded the trade the way they were supposed to. They were programmed in such a way, and that's the way the trade was concluded. So as far as we see, the trade was fair.
Just pausing there. The first ground of appeal is the issue of the DIFC court's jurisdiction. The lower court held that the DIFC court had jurisdiction, and the first ground of appeal is to challenge that conclusion. What do you say about that ground of appeal?
Your Lord, could you come again? I didn't get you.
So the first ground of appeal concerns the question of the court's jurisdiction, whether it has jurisdiction under Article 5 of the Judicial Authority Law. Before we get on to the merits of the case, that's the first ground of appeal. What do you say about that?
Your Lord, I'm currently addressing the other issue.
So is your co-counsel going to address the first ground of appeal?
Yes, Your Honor.
Okay, fine, that's fine. Normally, the first person to speak addresses the first ground of appeal, but if you want to reverse it, then as long as we make sure the right people are arguing, then I'm sure we can deal with that.
Is that okay, Your Lord?
Well, as long as the other team understand that we're arguing the second ground of appeal first, and they're prepared to deal with that, that's fine. You carry on and make your submissions.
Okay, Lord. Shall I proceed in that case?
Please do.
Okay. So as I was saying, the disputed trade was concluded the way it was supposed to. So in other words, Alpha and Beta program ran the way they were supposed to, and nothing went wrong with their programming. The only issue over here was the glitch. And we feel that Ms. Rajrani is taking advantage of this glitch for this case in her favor, as Alpha bought the best rate possible of YAPL at that particular time, and so did Beta sell YAPL to Alpha at a highly inflated price, the way it was programmed to. What we have to say here is, if this inflation of price and this disputed trade is unfair, as per Ms. Rajrani, the trade would have been avoided in the first place itself, as if this inflation of price by Beta or Mr. Lathpain's program was wrong or unfair, it would have been disqualified or excluded from trading by Clevity's platform itself. Ms. Rajrani,
what's the basis? Sorry, what's the basis for that submission? You say if there hadn't been a glitch, but it was at a highly inflated price, it wouldn't have been permitted on the platform. What's the basis for that submission?
Your Lord, with all due respect, it was hypothetical. My point over there was that whatever happened on during the 30 minutes of the glitch was fair and square. My point over there was, if according to Ms. Rajrani, Beta was unfair, Clevity would have dismissed the trade in the first place. But since Mr. Lathpain and his program Beta, they did not violate any terms and conditions of Clevity platform, nor did they do anything illegal, we have to say that the trade was fair and square. Ms. Rajrani implied that a reasonable trader would take appropriate precautions to avoid such disputed trades. In that case, Ms. Rajrani should have programmed Alpha in such a way where it would have avoided such trades, to avoid disputed trades from her behalf. And if Mr. Payne was unreasonably trading under Clevity, he would have been excluded from trading beforehand itself, as if he was unfair, he would have been violating the terms and conditions of Clevity platform. Ms. Rajrani's test.
Counsel, can I just stop you there? Do we have the terms and conditions for the ledger system Clevity? Can you draw my attention to those?
No, Your Lord, but No, Your Lord, we don't have the terms and conditions specifically, but I'm speaking from a general perspective.
Okay, please proceed.
Thank you. If Ms. Raji stresses that Ms. Payne took advantage of this glitch or error that was arise due to a routine upgrade on June 10, 2022, it is essential to point out that both Mr. Payne as well as Ms. Raji are traders or business people under this platform of Clevity, and taking advantages of such glitches or errors might be tricky, but it is okay, and it is not, as long as it is not illegal, it's okay for business people and traders to take such advantages of such glitches.
Here's a question for you. Both parties programmed their programs on the assumption that the Clevity platform was working normally. So that's the basis on which when they're dealing with the platform, they assume that it's going to apply its usual rules. And that's the basis on which they program. But the trade that was concluded was not concluded in that context. It was concluded in the context where the system had made an error which neither of them had anticipated. Isn't that the sort of circumstance in which the court should intervene to correct a trade that's been concluded?
Your Lord, we do recognize that on 10th June, there was an error due to the routine upgrade, but the only change the error brought within Clevity's platform was the rise of the minimum balance maintenance. It was risen from $50,000 to $200,000, but this glitch or error or routine upgrade, it did not affect either programs in any way. It did not affect.
That's obviously not true, is it? Because it affected them quite significantly, because it excluded everybody else from the market, and so produced a highly artificial a trading circumstance. Isn't that right?
You're absolutely right, my lord. But we feel that there is a possibility without this glitch with other users involved too. We believe that there is a possibility on this platform that the same trade would have been occurred without the glitch too, hypothetically. There is a possibility, even though the possibility or chance is less, we do believe that there is one where the same trade would have been occurred.
Okay.
The disputed trade was due to an error which occurred out of a routine upgrade on 10th June 2022. It's also mentioned in the facts that both the programs, alpha and beta, in fact, all the programs on Clevity are programmed in a way that they do not adapt to new changes. They do not adapt to new changes or new circumstances. And at the same time, Clevity is a program which is a software, a computer software, which is very prone to such risks, errors, hacks, or glitches. So we'd like to ask Ms. Razi that if she had foreseen such glitches or programs on her behalf and done her due diligence beforehand while programming her program alpha, in that case she might have had a chance to avoid such disputed trades. It's very well established and known fact to developers that these algorithms are not meant to develop new changes to new circumstances, and both alpha and beta are programmed automatically to conclude such trades without human physical interaction. And at the time of the disputed trade, Miss Rajdhani and Mr. Leithpain were both asleep and they were not aware of the situation. And again, coming back to my point, stating the above, that when both of them were asleep and the trade had been concluded, both the programs ran the way they were programmed to run, and there was nothing unusual or nothing different about the way they were programmed to and the way they concluded the trade. I'd like to point out to Article 16A of the International Chamber of Commerce, which states that the seller or beneficiary assumes no responsibility or liability for the consequences arising due to a trade or interruption to business. So according to this Article 16A of International Chamber of Commerce, Mr. Leithpain, the beneficiary or the seller, has no legal obligation or responsibility towards Ms. Rajdhani once the trade has been concluded.
But that surely doesn't affect the question of whether a contract can be set aside for mistake, because we're looking about whether a valid contract has been concluded in the first place, not about ongoing obligations as between buyer and seller after a contract has been concluded.
Your Lord, Ms. Rajrani had issued has issued charges against Mr. Leith Payne after the trade has been concluded. And
well, obviously, you can't apply to set aside a contract until someone has purported to make a contract. But we're still dealing with the question about whether a contract was validly formed, not about the ongoing rights and liabilities that arise out of it.
Your Lord, you're absolutely right, but the contract of Clevity clearly states that Clevity has nothing to do, the platform has nothing to do with a dispute between the traders.
Okay, carry on.
So may I proceed, Your Lord? Okay. So I've set out all my points and arguments over here. To conclude, I'd like to say that we request the court to dismiss this claim of Ms. Rajrani and understand that both the programs ran accordingly. And using Article 16 of International Chamber of Commerce and the other above arguments, I'd like to request the court to dismiss this claim. I would now transfer it to my co-counsel to address the first issue, the issue of jurisdiction.
Well, no, we go in a slightly different order. The next counsel to address us will be the counsel from the respondent dealing with this legal point. So I think that should actually be the junior counsel for the respondent, but whoever from the respondent is arguing the merits, the second ground of appeal.
Thank you, Lord.
Good afternoon, honorable judges. My name is Elena Cristina Talatini, and I am the junior respondent in this case. I will argue that the first instance court did not err in concluding that for the purpose of a claim to avoid a disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Rani showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. The DIFC law does protect the rights of parties who have genuinely made a mistake. A party may avoid a contract for mistake if, when the contract was concluded, the mistake was of such an importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and the other party knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. So I'm referring here to Article 37(1)(a) of DIFC contract law. The DIFC law is similar to the rules of a number of common law jurisdictions. Therefore, the court may elect to be guided by these persuasive authorities, although you are not to be bound by these. I will now argue that this is a case of unilateral mistake under the common law and under the law of equity, and that Ms. Rani has the right to avoid this contract. In common law jurisdictions, including England and Wales and Singapore, unilateral mistake requires that one party has transacted while operating under a mistake as to a fundamental term of the contract. Of course, algorithmic trades are novel and distinct in that the parties don't know what the terms would be until after the trading contract is made. In the case of coin and B2C2, in 2020, which was the Singapore International Commercial Court's first cryptocurrency judgment, it was applied to an algorithmic trade, and the judgment recognized that the existing body of law needs to be meaningfully adapted to deal with this type of novel situation. The coin judgment is relevant to our argument because it considered the question of how algorithmic contracts are formed. The majority opinion found that the contract formation took place where an offer was made by one algorithm and accepted by the other, and that the parties agreed to the contract using the deterministic algorithms. Therefore, the parties were content to abide by whatever algorithms were built within the parameters of the program. However, knowing about the mistake must be considered with reference to the person who created the algorithm, so to the programmer, when they created it up to the point the trade was made. So the question the court must consider today is, when programming the algorithm, did the programmer create it with the actual or constructive knowledge that the offer would only be accepted by a party operating under a mistake, or did the programmer act in such a way as to take advantage of this mistake? In our case, the respondent programmed Alpha to automatically buy Yapl at the best possible price on the Clevity program. The appellant programmed Beta to offer Yapl for sale at a highly inflated price if there are no other users offering to sell Yapl. Ms. Rani could not have foreseen a situation such as the one of the disputed trade, where only one party would sell Yapl at an inflated price, and that would not have happened were it not for the unfortunate error caused by Clevity's software update. We believe that no reasonable person in the same situation as our client would have concluded a disputed trade if the true state of affairs had been known. Unfortunately, Ms. Rani was asleep when Clevity excluded all other users from the platform except her program and Mr. Payne's beta program. She was indeed fully unaware of the unusual changes in market conditions on the Clevity platform. On the other hand, Mr. Payne, being well aware of the prevailing market price for Yapl, can easily deduct that the disputed trade, which happened at a price 250 times greater than the market price, could only have happened due to an error. It is contrary to reasonable commercial standards of fair dealing to leave Ms. Rani as the mistaken party in error. Moreover, when Mr. Payne programmed Beta to offer Yapl for sale at a highly inflated price if there are no other users, did he do so with the intention to take advantage of other algorithmic traders such as Ms. Rani, who could have never imagined a situation where only one seller would be available and dealing such a highly unfair price? And would Mr. Payne's beta program ever be the only one available seller in normal circumstances?
Is that right? Sorry, can we say that he was programming it to take advantage of other people's mistake? I mean, when the appellant programmed his program, he programmed it so that if there were no other participants in the market, which may not be the result of a mistake, may just be the result of people not willing to trade, that he offers a much higher price, but he's entitled to do that because there were no other parties in the market. So can you say when he programmed it that he was intending to take advantage of somebody's mistake? He didn't know that there was going to be an error on the platform, or that Ms. Razi's program would function in the way that it did in the event of that error.
Correct. We highly believe that he didn't do this intentionally, that the algorithm he created was for different circumstances, like the ones you mentioned before. That's why we are trying to prove that any reasonable person in the position of Mr. Payne when he discovered the disputed trade would have realized that this could only have happened through an error, not through the normal market conditions.
Okay, carry on.
Yes, and I would like to go further into defending our client's rights under the protection she is giving for unilateral mistake by the law of equity. And here we will follow the judgment in Coin versus B2C2, where the rule of law states that the non-mistaken party must have had at least constructive knowledge of the mistaken party's mistake, and the non-mistaken party must have acted unconscionably relative to the mistake. And if both parts are satisfied, the contract is voidable. So the court needs to determine that this constructive knowledge is objective. Again, would a reasonable person have known of the mistake? And we believe that yes, any other reasonable person would have known that this contract only concluded through a mistake from our client's side. In the dissent in Coin's case, Lord Justice Mans discussed the purpose of equitable remedies under the law. Equity may supplement the common law to give the court's jurisdiction in cases where there is a fundamental mistake of a nature not covered by the common law, and to give jurisdiction where the non-mistaken person lacks the requisite mental state required for common law relief. Lord Justice Mains held that unilateral mistake is an exception recognized by the law to further the ends of justice, and it is of a similar character to the principles underlying the law of misinterpretation and undue influence. He mentioned that in paragraph 180. He proposes that this was recognized in the case of digilantmall.com, when the court said that the law should not go to the aid of a party who knows that the objective appearance does not correspond with reality. It would go against the grain of justice if the law were to deem the mistaken party bound by such a contract. Allowing the law to intervene in circumstance-specific way, the underlying rationale is not a lack of correspondence between offer and acceptance, but is a principle of justice. Also, Lord Justice Mans stated that what can be known with confidence is that the mistake and its outcome in the form of the transaction was in human terms, not as fundamental as the sort of mistake at the issue in digitalmall.com. The reaction of any human trader, so we believe that this is very important, the reaction of any human trader viewing the transactions executed would have been fundamentally different if the transaction was happening on the spot and face-to-face. So we believe that Ms. Rani would have never agreed to the terms of the contract was she dealing or trading face-to-face with Mr. Payne. Therefore, Your Honor, we plead to the court to give due weight to these considerations under the law of equity. It is clear that Mr. Payne had constructive knowledge of Ms. Rani's mistake, and Mr. Payne acted unconscionably relative to the mistake. We could not emphasize this enough. Any reasonable person, knowing of the circumstance, would know there was a fundamental mistake. Equity's conscience must be evoked. It is truly unconceivable that Mr. Payne to insist that the contract be performed and seek to retain the benefit of an unfortunate mistake from our client's side. Again, the reaction of any human trader viewing the transactions excluded would have been that they were fundamentally misconceived, that it is the result of a fundamental mistake that no buyer would agree to in the prevailing market conditions. The law must be adapted to our case and to the new world of algorithmic trades in a way that would ensure justice and fairness are preserved. It would go again against the grain of justice if the law were to deem Ms. Rani bound by such a contract. Thank you very much.
Thank you very much for those submissions. Now the senior counsel for the appellant has 5 minutes of responsive submissions, if he so wishes.
Mohammed, are you there?
Yes, Your Lord.
Yeah.
Whenever you're ready.
I'm sorry, Your Lord.
You've got 5 minutes if you wish to make any responsive submissions.
Sure, Your Lord. I'm sorry. I was just writing down my responses.
That's fine.
I'd like to ask, can I call you Christina?
No, you can't ask anybody anything. You've just got to make submissions.
Yes, Your Lord. Leith Payne, I'm sorry. The junior respondent said that Leith Payne should have reasonably programmed beta in such a way that it would avoid such unfair transactions. Leith Payne did not violate any terms nor do anything illegal whilst programming his program beta. So even if it did take advantage of such situations, as long as it's not illegal, to our arguments and in favor of our client, Mr. Leith Payne, we feel it's fine. Again, the same question, hypothetically, if the same trade was occurred without the same glitch, would there be the same issues under the same courts? And the junior respondent again stated that Ms. Razi would have never accepted the same trade if the trade was physical and not on a platform such as Clevity or not algorithmic trading. We'd like to point out that Ms. Razi needs to understand the risks of such algorithmic tradings and trades that occur without physical human interaction. So I would conclude by saying that this trade maybe was an error on her side or a loss on her side because of algorithmic trading.
Okay, thank you very much.
Thank you, Arun.
So I think we will now hear from, hopefully, the junior counsel for the appellant, arguing the jurisdiction ground.
Yes, Your Lordship. May I start?
Please do.
Your Lordship, my name is Muhammad Umar, and I am the co-counselor on behalf of Mr. Payne. Your Lordship, I will be presenting the issue of jurisdiction. Do you have your permission to proceed with the issue?
You do.
The issue is if the court of the first instance conclude that for the purpose of a claim to avoid the disputed trade was sufficient for the purpose of satisfying Article 37, Clause 1, Clause A, that Ms. Raj show that a reasonable trader with knowledge of the circumstances of the transactions would have concluded that the disputed trade was the result of an error. Your Lordship, this is the issue we present, and may I proceed with my arguments?
Yes, assume that you can proceed with your submissions until we interrupt.
Thank you, Your Lordship. So starting with my arguments, did the first instance court determine that Ms. Raj proved that a reasonable trader with knowledge of the transactions circumstances would have concluded that the disputed trade was the result of an error sufficient to satisfy Article 37, Clause 1, Clause A of the DIFC contract law for purposes of a claim to avoid the disputed trade? Ms. Raj's claims against my client, Mr. Payne, is plainly misinterpreted in the light of Article 5, Clause A, Clause 1 of the Judicial Authority Statute of the UAE, which states that such claim may only be brought in the DIFC if the DIFC had exclusive jurisdiction over the dispute. Your Lordship, there is no commercial regulatory body or specific law for crypto assets that considers cryptocurrency to be a tangible property, which shows that such a claim before the DIFC Digital Economy Court is obviously invalid. Crypto regulations are still a relatively new area for legislations in the UAE and under DIFC. The regulatory bodies concerning cryptocurrencies in UAE are VARA, the first of its kind regulatory organization. VARA oversees and controls the trading of cryptocurrencies across Dubai, with the exception of the DIFC. VARA is in charge of licensing and overseeing the virtual.
If that body has a regulatory function with the exception of the DIFC, doesn't that mean that the DIFC must have jurisdiction to consider issues relating to cryptocurrencies where there is a connection to the DIFC?
According to my knowledge, DIFC doesn't have any proper law based on cryptocurrency trading.
But we're concerned here, aren't we, with just a contract to buy and sell an asset, and whether it's a whether it's a cryptocurrency or a piece of artwork or oil, doesn't really matter, does it?
Your Honor, I'm not able to answer this question, and I will refer to it.
My question is, your submission is that the DIFC court does not have jurisdiction to deal with anything to do with cryptocurrency. That is quite a bold submission, and I'm trying to understand the basis for it.
The DIFC doesn't have jurisdiction over the cryptocurrency trading, as I have another governing agency that exclusively regulates virtual assets like cryptocurrencies and NFTs in Dubai. But both the organization that deals with crypto trades and crypto assets are unable to in any way defend against this allegation. The DFSA controls the assets and cryptocurrencies, but not their actual trades. So that cannot be used in this case.
Yes, but this is just an ordinary, this goes back to my first point, which is that this is just an ordinary contract between two private citizens to buy and sell a cryptocurrency. Why is that something that is not within the terms of Article 5? Imagine both of them lived in the DIFC and they met in a cafe in the DIFC, and one of them said, I'll buy 100 Bitcoin from you, and the other one said, yes, okay. Why would that sort of contract be outside the jurisdiction of the DIFC court? I mean, that seems to me a paradigm case that they would fall within the DIFC court's jurisdiction.
So the only two regulatory bodies right now, they don't have any jurisdiction, and as for the contract, if as per the Article 5, Clause A, Clause 1, the DIFC, if it doesn't have exclusive jurisdiction over the dispute, the claims cannot be brought to it.
Well, let's look at Article 5A1, because Article 5A1 says the court of first instance shall have exclusive jurisdiction to hear and determine, and then A, B, C, D, or E. So it's saying the DIFC court has exclusive jurisdiction if the claim falls into A, B, C, D, or E. So the issue here is, does it fall into B or C?
I'm not sure. I'll need to refer this with my main counsel.
Okay, well, you've got to, your time is ticking, so make whatever submissions you feel you can.
I have a case law on this.
Okay.
It is such case that is seen as a landmark precedent for cryptocurrency related cases. On February 8, 2020, Dr. Wright, owner of Tulip Trading, witnessed the disappearance of Bitcoin from his digital wallet, said to be worth around $3 billion. He soon filed a lawsuit in the High Court of England and Wales against the developer of the company's core software, arguing that the developer had a duty to counter the consequences of the hack. Judge Fogg was convinced that this was such an important issue that a fair trial should be held. But Judge also said that the Tulip Trading has the same duty, whose responsibilities are not specific to core software developers. Another factor that persuaded Judge to dismiss this argument was the software developers had responsibilities, but those responsibilities were designed to prevent hacking rather than counterattack their impact on the company. Referring to this case, Dr. Wright lost $3 billion and his claim was dismissed, even though it was in the jurisdiction of the High Court of England and Wales. How can Ms. Raz expect her claims to be valid if they are due to fair trading under well-established crypto trading platforms? Your Lordship, that is the end of the arguments from our side.
Counsel, your submission is that the DIFC does not have jurisdiction over this claim. Is that correct? Yeah. So can you assist the court, please, with who, in fact, in your submission, does have jurisdiction over a claim of this kind?
Your Lordship, we are requesting that the case must be dismissed as none of the regulatory bodies has jurisdiction over the DIFC and our case. There are alternate courts which the party can approach, and such courts can be explored by the responding party.
Thank you, counsel.
Thank you. So we will now hear, I think, from senior counsel for the respondent arguing the jurisdiction point.
Thank you, Your Lordship.
Thank you very much. Good afternoon, Your Honors. I'm Tasneem Ilyas. I'm the senior respondent representing Ms. Razwani against Mr. Leith Payne on appeal from the DEC. I think our stance was pretty simple. On the first issue on appeal, we argue that the trial judge did not err in applying Al-Khurafi versus Bank Saracen in concluding that the DIFC court had jurisdiction over the claim by Ms. Razi against Mr. Payne under Article 5A1 B and C, and this is something that I'll be arguing later. Our stance was also clear about how the trial judge did not err in concluding that it was sufficient for the purpose in satisfying Article 37(1) and 2 of the IFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the dispute trade was a result of an error. So you've already heard from my junior respondent who already dealt with the second issue. I will jump right into the first issue about why the DIFC has jurisdiction over the claims due to the event, incident, and activity regarding a transaction that were wholly or partially within the DIFC. And I'll refer to Articles 5A, 1B, and C specifically to prove this. If we look at the Articles 5A, 1B, and C, B says any civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded within the DIFC. And C talks about how whether civil or commercial claims and actions arising out of or relating to an incident or transaction which has been wholly or partly performed within the DIFC and is related to DIFC activities. So what we want to argue is on the issue of jurisdiction, that the fact of the geographical aspects of the distribution ledger and the nature of the node itself being within the DIFC means that the DIFC has jurisdiction. We are predominantly going to be looking at Al-Khurafi versus Bank Saracen, and we're going to draw a parallel between their decision on how a branch necessarily wasn't a separate entity, but an extension of a legal entity found in paragraph 102. Therefore, that the place of jurisdiction for proceedings to which the legal entity is a part shall include its extensions. And this is under the assumption that the entity will be sued or sue in that place. So if we look at, this is paragraph 101, when the court in the first instance analyzed Khurafi versus Bank Saracen, they said that the place of jurisdiction for all proceedings refers to the place or the proceedings, and in that instance, for which the bank is a party or the bank and clients are parties in agreement. The assumption is that the bank will be sued or sue in the place of jurisdiction, and it determines the place of jurisdiction is the location of the branch which the business relationship exists. So what we argue is that in this instance, because Clevity operated through a distributed ledger and it had a node within the DIFC jurisdiction, we're going to draw a parallel and say that this is akin to the branch that was referred to in Al-Khurafi versus Bank Saracen, and therefore the jurisdiction here the DIFC should have jurisdiction.
Why, can I pause you there? Why is the having of a node, which is equivalent to, part of a server, should that be in law equivalent to a branch? I mean, if I open a branch, that's creating a part of a legal entity in a particular jurisdiction. So it's very much about having presence in a particular jurisdiction. But a node is just a server. I can go and I'm based in England at the moment. I could go and rent a server in Dubai. But does that mean I'm engaging that court's jurisdiction in the same way that I would be if I were to open a branch of my company in Dubai? I want to understand why you say these two should be treated equivalently.
Because the node in this instance and the server is independent enough that it can actually have or conclude either partially or completely these transactions. So the argument that we are trying to make here is that node, even though it might seem inconsequential, but in the world where everything has gone virtually, that small little node and server is equipped and able to conduct all of these transactions. And that is why we say we make a case that due to the proximity and due to the location within the DIFC and the proximity of both Mr. Marazrani in Dubai and Mr. Payne in Oman, that it is very likely that partially or wholly this transaction was completed using this server and this node that was based within the DIFC. So this is the contention that we are making.
Okay, carry on. Thank you.
Okay. So this is similar to what happened in Switzerland, because a similar argument was put up in this with regards to whether Switzerland should have been the entire whether Switzerland should have been the site, but the case in Khurafi versus Saracen said otherwise. The second thing that we wanted to argue, again linked to this, is that whether the transaction did take place. So if we look at C specifically, for DIFC to have jurisdiction, incident and activity with regard to the transaction or contract must be wholly or partially within the DIFC. When a particular commercial activity is carried on, it further results in an incident or a transaction to the DIFC, then it has jurisdiction. So this is, I'm quoting from Al-Khurafi versus Bank Saracen, paragraph 60. So where any essential element or conduct of loss occurs that gives rise to an action, DIFC has jurisdiction. So we would like to say here that an essential element of conduct or loss has occurred due to this node that is within this jurisdiction, and therefore the jurisdiction applies. In Al-Khurafi versus Bank Saracen, the claimant's contract was accepted within the DIFC because of telephone and email exchanges, which wasn't exactly or necessarily the whole contract, but it was still accepted partly or wholly because it was performed within the DIFC. So in this instance, we would say that the essential element of commercial activity occurred at the DIFC. The node was within the DIFC, hosted servers that allowed for the trade to take place, like Saracen, where the branch within the DIFC was used to carry out essential elements that gave rise to these actions. The investment activities carried out in the branch of the DIFC, it's a very similar case here because the servers hosted on the node facilitated that transaction between Ms. Rani and Mr. Laith. So that's why we believe here the jurisdiction arises. I think necessarily, one more thing that we wanted to
Can I ask a question before you proceed? Clevity, like a lot of distributed ledgers, has hundreds of nodes scattered throughout the world. Is a consequence of your argument not that for a dispute between these two parties, one based in Oman, the other based in onshore Dubai, there could be hundreds of courts across the world that could have jurisdiction if it's sufficient that only a single node is enough to engage a particular court's jurisdiction? Is that something that the court should be concerned about forming the law in such a way as to give hundreds of courts that may have absolutely no other connection to the dispute potentially jurisdiction over this sort of transaction? And isn't that going to just lead to a lot of fights in a lot of courts and a lot of forum shopping?
I think what we're trying to do here is actually move away from forum shopping, because I think the problem here is when we try and say that the DIFC has no jurisdiction. This is when, for example, that is why our esteemed appellants were saying that we should use another court, but we're not very specific as to what necessarily that court would be. And I think that that is the problem that the DIFC is trying to address here. I think that with the concern of whether any node that will have no link to the transaction take place, I feel as though in those instances, it might be very difficult for a court to claim jurisdiction if there was in no way any connection. That is why I feel in this instance, if we can prove that even if there was partially some kind of transaction that passed through, and the likelihood given the fact that of geographical proximity of this node existing within the DIFC and the location of Mr. Payne and Ms. Radi shows that it's highly probable that it was this node within the DIFC. We feel like this shows that there is some sort of link between that transaction, and that is why this court has jurisdiction. I think this leads very nicely to the second thing that I was going to say about how this is especially solving the problem that you have just outlined, is that when we are moving into a frontier of cryptocurrency and moving into a frontier of 100 nodes all around, who then has jurisdiction? And this is where we believe the fact that the DIFC has launched specialized courts for digital economy is very important. And that's why we wanted to draw your attention again here to 58. So we have in Article 58.7 of the digital economy court rules, and it includes a distributed ledger technology as part of the DEC and claims relating to digital economy. So if you look at 58.73, it talks about distributed ledger technology and blockchains, including applications based on blockchain technology. And what we feel is though, and we have to concede that this law has not been put into full effect, but what we feel is that this is the direction in which the law is heading, in which we have to try and sort of find a way in to regulate and find a way to deal with these issues that always arise. So that's why we believe here that if the court recognizes that this technology and recognizes and will recognize soon that distributed ledger technology falls within it, and blockchain falls within it, then the DEC is designed to hear cases regarding emergent and current technological advancements. And this will be better for dealing with problems of forum non-convenience under private international law. We feel like it's a better chance than going forum shopping or going to Oman or going to UAE courts or going to Clevity's courts, wherever that may be. So in the interest of justice, convenience, and fairness, we argue that not only does the DIFC have jurisdiction, but that it is the best forum in this case due to the matter at hand and due to the resources that are available. And we don't see any instances that would make this a less sort of a favorable option.
Thank you. It's always a good submission to flatter your bench. I think we now have, for the final submission, make sure I get this the right way around, senior counsel for the appellant. No, sorry, junior counsel for the appellant. For 5 minutes of responsive submissions. Mohammed Umar? Sorry, sorry, I'm getting myself confused, aren't I? It's junior counsel for the appellant. Mohammed Umar.
Yes. I want to ask her.
There's no asking. There's just submissions.
Right. We would like to know that if the branch and the node she has addressed to are the same.
Her submission was that in a decision of the DIFC Court of Appeal called Al-Kharafi, it was sufficient if an entity had a branch in the DIFC to give the DIFC court jurisdiction. And her submission, a very creative submission, was that a node should be treated in the same way as a branch. So you should reason by analogy. That was her submission. So she wasn't saying there is a branch in the DIFC. She was saying that a node should be, the law should treat the node in the same way as it treats a branch of a company.
Okay, Your Lordship, I have no further submissions.
Thank you very much. Well, thank you to everyone for taking part. Amrit and I are going to consider our scores, and we pass them on to those who are running the competition, and you'll find out which teams progress to the next round. Unless you've got any questions, we might do just a very broad bit of feedback. I don't know, Amrit, whether you wish to go first and give some very general feedback to everybody.
Yes, happy to do so. Thank you, Matthew. Thank you to all of you for being here, for participating and making a good effort, if I may say so, in this particular round. Just some very brief sort of headline remarks. Obviously, when you're preparing for this, it's very important that you go away and you look very carefully at the provisions, the authorities, and any sort of legislative sort of provisions that you're looking at, that you look at it in its entirety, and you understand quite carefully what exactly the law says when you come to applying it to the factual matrix. So it's very important to do that when you're framing your submissions, and perhaps the order in terms of the way in which you present your submissions to the court and the according weight that you apply to your various arguments. Other than that, I think it's always important when you're making oral submissions to make sure that your structure is abundantly clear as you move around various arguments that you might have, and make sure that the court is following you as you wish it to do so, and make sure it's not sort of left behind wondering how you've jumped between perhaps one argument to another. That's just a sort of general helpful comment, I suppose, when it comes to sort of a differentiation between obviously written submissions and then when you come to presenting them orally. So I hope that provides some assistance for all of you. And I wish you the very best of luck as you may progress through the various rounds of this moot.
Thank you, Amrit.
Matthew, I don't know if you had...
I agree with all of that. The only thing I would add to it, which is a piece of feedback for both of you, is that it's very helpful if you include your authorities with your skeleton arguments or with your bundle, so that you can take the court directly to a passage or a legislative provision that you rely on by saying, please go to page 18, and there you will see Article 35 of the DIFC contract law. And then it's a lot easier for the judge to engage with what you're saying. But unless there are any questions from anyone, which we're very happy to answer, then I think you can all log off.
No questions. Thank you so much.
Thank you very much.
Thank you, everyone. Thank you.
Thank
No
you.
questions.
Bye-bye.
Thank you.